All right, well, thanks for coming. My name's Rick Sanders, and I've been asked to talk about sort of legal stuff. My background is pretty general in intellectual property and computer issues, so it's broad enough probably to at least take a decent stab at your questions. And I think the idea was that this would be more of a Q&A, but I do have a kind of boring presentation which I can kind of launch into. Well, platypus is sort of a metaphor. It's sort of a metaphor that made sense last night. So I don't know how much sense it makes today, but
last-minute metaphors are best.
well, see, that's the problem. It was last minute, but that's not last minute anymore. So
No longer time.
yeah. Well, I thought the presentation is about sort of the interaction between the law and software development. And the reason why I used a platypus as my symbol here is that software is like in the law, software is like a platypus. It doesn't fit neatly into any of the categories that intellectual property law was designed for, and it makes life hard for judges. It makes life hard for lawyers. I love it because it's complicated and difficult, and it's kind of a big puzzle that you have to kind of work through. But it's frustrating for everybody else. So that's why the platypus is our symbol today. Software development is like it's not quite patented. It's not quite copyright. It's not quite trade secret. It's something sort of all its own. Do you want me to just kind of launch into the presentation? You guys start asking questions, or do you want to start asking questions right off the bat? Presentation, all right.
And then we'll interrupt.
Then you, okay. All right. So, all right, that's me. Work for a law firm up in Nashville. Me and my partner, lovely and attractive Tara Aaron, and I do the litigation side, and she does the transaction side. So the idea is that if she does her job, I should never see you. But fortunately, people do not take legal advice, and that keeps me in business. So I do the lawsuits, I do the litigation. And if you're ever interested, I do keep a pretty regular blog. I try to aim it at people who are not lawyers but are interested. So it's not fluffy, but it's not for lawyers either. So this is where I was last night. I was trying to think of what's software like, what's software's relationship with IP like, and at first I thought it was like the Maginot Line in Belgium. Okay, few people get that. Okay, but then it's not quite right. It's sort of it belongs everywhere and it belongs nowhere. That's where software development is. And there's lots of little specific, very very specific laws out there. Some are state specific that we're just not going to have time to get into. Particularly if you want to get into internet issues, which is another completely different issue, which I could spend another hour talking about. But so these are three main areas of IP that affect. Yeah, that's an interesting question. You're thinking. I've been told that everybody's going to be interested in the Apple Samsung case, and yeah. Yeah. I think two issues. Obviously, it's going to be more important for hardware, for devices like this. And what we learned, first of all, that thing's going to be on appeal. I mean, I hate to draw too much from that case because more and more is coming out about it, and it's looking weirder and weirder. And it's already weird to begin with. When it comes to trade dress, we're actually talking about two different things. And in the Apple case, there were two different sorts of trade dress. One is a design patent. And design patents are like regular patents, except you remove the word useful and you add in the word ornamental. And people used to think they were kind of lame. They're easier to get, but they still cost a lot, and they still take time, and they're hard to enforce, because until like 2 years ago, nobody knew quite what the test was, and people used to laugh at them. I mean, all the other forms of IP would kind of laugh at them, maybe behind, design patents back, patents, utility patents and copyrights would, even trademark, kind of laugh at it. But the Apple-Samsung case, I think 24% of the $1 billion in damages was owing to a design patent. So people are now rethinking maybe design patents are worth more. But you have to go to the USPTO, and I'll talk about that in a little bit. But you still have to go to the USPTO. You got to pay filing fees. You got to pay a lawyer to do all the back and forth. Trade dress, Coke bottles is your example of a trade dress. You see a Coke bottle, you think Coke. I mean, nobody can have a Coke bottle shaped like that anymore, because the shape is so tied to a particular product. So it's actually in the realm of trademark. And I didn't talk about trademark here, but trademark is really, in some ways, it's the least IP of the types of IP, because it's really kind of a business tort. I'm your customer, and I see a mark, and I think your goods, your services. And once that happens, there's a trademark. You don't even have to go register it. Common law says there's a trademark. This is the oldest kind of IP. It goes back to the Middle Ages. It goes back to the old palming off. If I'm selling apples and my apples suck, but your apples are great, and I say, oh, these aren't my apples, they're your apples. I'm lying to people. That's how trademark got started. You can sue me and say you were palming off, claiming your products were something that they weren't. And now it's become abstracted to this idea of marks. Apple, of course, a strong mark, but also trade dress. But trade dress is hard. Trade dress is hard to get. It's pretty unusual because you have to prove that consumers are actually making the association. If you got a nice strong mark like Apple, you don't have to prove that. Everybody just assumes that's a distinctive mark and you're there. But with trade dress, you actually have to figure out some way to prove that consumers are making the connection, and that's really hard. I mean, how are you supposed to do that? You're supposed to ask 1,000 people to come into the courtroom and say, yep, 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 nope, yep, yep, yep. You gotta hire experts. They gotta do surveys. They always blow the surveys. I mean, about 50 or 2/3 of the times they blow the surveys, and their testimony is thrown out and it fails. I don't know. Trade dress, no, but maybe design patents are maybe they're not getting picked on anymore. It depends. I'm holding judgment until I see what the Ninth Circuit does with the Apple-Samsung case, because boy, the jury went nuts on the design patent. Sorry, did that remotely answer your question? Yeah, it is. You had your hand up first.
Long before,
yes,
long before that was a patentable or an IP issue that is now associated intricately with the Coca-Cola company. But yet, if something like the iPad, which was asserted, the rectangular shape with round corners, asserted that now that is something that's associated with Apple, yet that's only been around for 3 years.
Yeah, and what's interesting, we don't know why. Apple lost the trade dress. Jury actually went against Apple on trade dress. They went for Apple on the design patent. So maybe that's what they're thinking. The problem with juries is they're kind of a black box. We don't know why they do things. They just come back with mystical numbers and say it's $1 billion. But it was the design patent. So Apple had previously gotten a design patent. Apple's become very aggressive with their patents. And so they got the design patent, and there it doesn't matter. All it matters for a design patent is that you were allegedly the first person to come up with the design. Whereas I think you're absolutely right. Your instincts are exactly right about trade dress. That it's been around a while is sort of necessary to build up the goodwill so that you have this intrinsic connection that consumers are drawing between your product and you, the producer of the product.
Well, at the same token, when you have a device that comes out that is anything, an example in tablets, in that same very short time frame, you have lots of
they all can, look the same or look very similar. But
Yeah.
it's sort of a question there of is culturally we like circles this year. But can one company own a circle?
No. I mean, that's the thing. You can't own what's already in nature. And that's what's so kind of controversial about the idea of having a trade dress. I think there's a bit more to it than just the rounded edges, but it's a pretty broad patent that Apple won on.
Can you go, I'm not getting, you're talking about they won the design patent, but not the trade dress.
Not the dress.
But I have no idea how the two are distinct from each other.
Okay, so a design patent is something you get from the government. So you have to go to the government, you fill out an application, you hire a lawyer, you pay the lawyer a pretty good amount of money. They're cheaper to get, and they're cheaper, therefore, than utility patents, but still, filing fees and attorney's fees are expensive. And you say to them, I've got something that's ornamental, nobody's ever had this design before, and nobody had ever, if they were aware of it at the time. And then if you convince the USPTO of that, shazam, you got a patent. It might take a few years. That's the other thing, it takes a few years. But then when you got it, you can go out and enforce it on people and sue them. Trade dress is something that arises organically. It arises between your relationship between your customers and your product. And your customers see your product and say, that shape, that color combined with shape. Recently we had a ruling about red soles on the shoes. There are also some restaurant concepts have managed to succeed. You say, I see that, and I immediately think a certain kind of quality. I mean, that's what trademarks and trade dress are supposed to say, is a certain quality, not necessarily high quality, but a certain experience, a certain level of quality that is now associated with that mark or trade dress. And it happens organically. You can try to get it registered. It's sort of an interesting thing you can do. You can get it registered. That gives you a certain amount of national coverage, but it happens organically. It has to happen organically. The government doesn't grant it to you.
Yeah.
It's through your efforts, your marketing, your advertising.
Thank you. Another thing I wondered after the decision came down from the Ninth Circuit was, it just seems a little weird to me. We've got this Korean company, and we got this California company, and so we're going to have an all-California jury rule against the Koreans, and I'm like, well, we got a little home field bias here now, don't we?
Yeah, it's I've been thinking about that, and I used to practice in California. Used to practice in Santa Clara County, and what's weird about patent cases is that the plaintiff almost always wins if it gets to trial. It doesn't really matter where you are. Many lawsuits, for example, are brought in Eastern District of Texas or Eastern District of Virginia, not because that's where they're located, but because they're very friendly juries there. But still, juries just kind of go with the plaintiff on patent cases. And what's weird is they do it even if it's a declaratory action. That is, the person likely to be accused of infringement brings the lawsuit preemptively. Juries just seem to go with whoever took action. Now the question is there some kind of home field advantage? Part of me, I'm split.
It seems like if I was involved in the appeal, I would be like, you've got people literally 30 miles away from headquarters here that are actually involved in the economy there, and so, yeah. Whose side are they going to take? It's quite obvious.
Yeah, I mean I'm sort of split on that, just because people.
Well, I'd argue the hell out of it.
People in Santa Clara County are mostly from somewhere else. I mean, it's sort of a weird thing about Silicon Valley. I grew up there, so I'm actually unusual in that I was born and raised there. But my dad's not from there. My mom's not from there. A lot of my friends are from India or from China or somewhere else. But the jury pool is a little different. The jury pool tends to be made up of a lot more homies. And I remember being involved in a case there. It was awful. Our client was from India, from southern India. And we somehow in Silicon Valley had almost an entirely white jury. I don't know how you do that. And we got killed because the plaintiff made our client look like this sort of outsider from India, and here they are being successful. And there's a lot of people in Silicon Valley who are kind of resentful of people who live in Santa Clara County are sometimes resentful of Silicon Valley.
Nice.
And now that was several years ago. Silicon Valley has changed even more since I left. But I remember being a little stunned by that. So yeah, home cooking. Federal courts are supposed to be less home cooking. You've never been home cooked until you've been home cooked in Texas state court because the judge hates you. But yeah, maybe if so, Samsung should have. I guess the only thing they could have done is brought the lawsuit somewhere else. But it's not going to be a factor at all on appeal. We assume, we get very naive about juries. We assume that, now this may be unusual because the foreman did some strange things, but generally we assume juries are wonderful, hardworking, honest, completely fair people. We just assume that.
I thought they were regular people.
Yeah. No, honestly, we really think of them as more than that. Yeah. Well, I think we do that because otherwise we'd go insane. If we questioned every single jury decision, we would never hear the end of it. So there has to be something that's the end. And with juries, the jury decisions are very rarely overturned. Because of that. It's a black box. We don't know what they were thinking. Juries they don't like jury instructions very much. Patent cases especially so because the jury instructions are massive and the issues are very technical.
As technical as my thing's got roundy corners and they stole it.
Yeah.
And that's when they were warming.
This is not a very technical case. Now I'll admit only one of the patents was really very technical.
When they were warming up to the verdict being released, I was making jokes on Facebook that the lawyer got up there in front of the jury and said, "Oh, it's got roundy corners. That's mine."
Yeah. I'll just tell you. I try very hard not to ever take sides because I never know who my next client's going to be, and obviously the side I'm taking is whoever my client is. But the verdict disturbed me, and it wasn't because they found infringement. Two things really bothered me. One, it's coming out more and more that they were ignoring prior art. The jury ignored prior art, and that really bothers me. And it turns out it's very common. Prior art, by the way, is inventions that predate the filing date of your patent. And it seems like there was a lot of prior art they just didn't look at. But second, the damages. Often the problem isn't the infringement, it's the damages. And I read a great analysis of this case. Remember, there were 3 utility patents and 1 design patent. The design patent ended up being like 27%, but one of the patents was the rubber band. Can I do it on this? Does it work? No. When you have on your iPhone and you scroll down and it kind of bounces back. That was one of the patents, and I think okay, that's neat. That's neat, and neat things deserve to be patented just as much as earth-shattering things. That's a basic rule of patentability. As long as some kind of non-obvious improvement, that's fine. My problem is the damages. If you were to take an iPhone or an iPad, and you broke down every single feature, and you assigned the same amount of money that the jury assigned to these three patented features, apparently an iPad should be worth $1 million, and it's worth $199, or I go with a Samsung device should if you break it apart together, it should be $1 million. Instead, it's a $200 device. And that's a problem not just with patent law. It's a problem with the whole any time the jury gets involved, the numbers just seem to inflate. I don't know. I get the sense that sometimes it's like, hey, I spent a week doing this. Somebody's gonna pay. Oh. No, not really. And patent law, and this is something that's ripe for reform, but patent law is very vague about damages. All the Patent Act says is that you get, at a minimum, a reasonable royalty. And then there are these 14, and I'm afraid I don't have them memorized, but there's 14 what are called the Georgia-Pacific factors, which include things like evidence that this feature is very important, or evidence that there's been a long-felt need for this, or something like that. But evidence that that would show how valuable this is. And you're supposed to imagine, for a reasonable royalty, you're supposed to imagine this hypothetical negotiation that can't ever happen, which is if the patentee, that is the guy who owns the patent, and the infringer were to, before the lawsuit, get together and have a negotiation, how much would the infringer have paid the patentee and how much would the patentee have taken from the infringer? The problem is you're supposed to ignore the fact the patentee has a patent. And the problem with the patent is if my device has rubber band, say that's the only thing, it's got rubber banding on it, and it's already out there, I can stop you from selling it. And suddenly that little feature grows into this enormous block, which you're not supposed to take into account, but everybody does, because everybody keeps thinking, oh my God, if they don't have a patent, they can't even sell this thing. Of course, Samsung can get around it going forward by getting rid of the rubber banding or whatever. But yeah, it's not so much math. Math's hard, but it's just that there's not a lot of instructions, and even if there were, there's no guarantee they're going to follow the instructions.
My question is, so I saw that the Patent Office, I believe, tentatively just basically said the patent was invalid for one of the patents.
Yeah, one of the patents.
So what happens if that patent is completely invalidated after the case?
It's not happened before, and a lot of us are wondering. Because this new what we call post-grant review is relatively new. We've always had reexaminations, but they were hard to do. The American Invents Act of 2011 made it a lot easier. I have to think if the case is ongoing, just applying basic litigation principles, the case is ongoing at that time, we don't have a final decision, then Samsung should be able to go back to the court, ask for move to alter or amend. It seems like they should be able to. We've got a ways to go on that, and I'm curious to know what the Court of Appeals will do. Yeah, they can ask for a stay. I don't think they have. I tried looking at the docket. It's kind of a bear of a docket because they file all kinds of stuff. These are, I know both law firms that are doing this. they're the sort of people who. Well, this is a perfect case. This is a perfect case because the amounts of money involved. Lawyers look. Whether a lawyer is expensive or not depends on how much money is involved. And if $1 billion is involved, suddenly lawyers look really cheap. So yeah, there's a lot of throwing everything they can at it. But it looks like they haven't asked yet, but maybe it's a little premature because right now they're at a position where they're asking the judge to step in and maybe reduce the award through something called remittiture. So we're still at a stage where they're asking the judge to intervene and perhaps overturn some of the jury's findings. And then maybe once it goes on appeal, they will ask the Ninth Circuit they'll appeal timely, then they'll ask the Ninth Circuit to stay. I'll be watching that because it's never happened before. This is such a high-profile case. If you don't mind, I'm just going to go with that guy in the back and then come to you.
Thank you. So there have been at least a couple of court cases where places like MapQuest have sued other mapping locations for having too similar of a route, even though in the very first case I remember, which was I think back in 2002 timeframe, the other company proved that they used a completely separate algorithm to come to the same conclusion, but the judge still ruled in favor of MapQuest for saying, hey, look, you displayed the same route, so therefore there was an infringement.
Do you know, unfortunately, I'm not familiar with the case, but do you know if that was a patent or a copyright case? Okay. Because if it were a patent case, that would actually make a little bit of sense. Because patents cover functionality and ideas, so long as they're novel, non-obvious, and useful. And so long as they aren't describing a law of nature. And so with the patent, it wouldn't matter how you did it, so long as you did it, so long as you had the same functionality. Now, what's supposed to protect us from crazy patents is this novelty requirement. But we can talk a little bit later. Is with software patents, business method patents, the examiners are at a real disadvantage with finding prior art. Now, with copyright, if they use totally different code, they should have been okay, because copyright protects the code, not the ideas. And for a while there, it looked like copyright was going to just overtake patent way back in the early 90s, but now it's regarded as kind of a lesser way of protecting software. So if they use totally different code, that is, if they coded it separately without reference to MapQuest's code, they should have been okay. I don't remember those cases. Perhaps in 2002 I was busy doing something else.
I want to shift gears for a minute and talk about actually statutes.
Okay, are we ready to shift gears? Okay, you have follow-up, okay. Yeah. Yeah, I know what case you're talking about. We're all on pins and needles about this. Is Kurt Sang. Do you mind if I talk about Kurt Sang for a minute? I love Kurt Sang. Okay. By the way, I teach copyright at Vanderbilt, and I just taught this course, so I've got it kind of this case, so I've got it in my head. All right, it's illegal to import copyrighted things without permission. Okay. All right, that's not a big deal. It's amazing, though, what? Why? It's just the law says so. Congress passed a law and they said so. But, well, the reason, the policy reason, is to avoid gray market goods. Okay, gray market goods. You know, particularly, Kurt Sang's great because it involves books. You know, Thailand has a lower cost of living, so Wiley sells their books for less in Thailand. And so what they don't want is they don't want these cheap books being being imported into America and undercutting the more expensive price point that we have here. So that's the gray market. That's the gray market problem. That's kind of what it's supposed to do. But what's weird is what's copyrightable. The first case of this type was called Quality King. It involved hair care products. Wait, hair care products? That's how you copyright hair care products. Well, they didn't care about what was inside the can. They cared about the writing on the can. You know, it's copyrightable, I guess. And in Quality King, the products are manufactured here. They were then exported, and then somebody got them cheap and re-imported them. Supreme Court said that was okay. Because once you buy something, a copyrighted item, the first sale doctrine kicks in, and it's yours. You can do with it what you want. I mean, you can't copy it, but you can sell it, throw it away, do what you want with it, right? We'd go nuts if wasn't such a thing. And that's okay, right? With hair care products, once you've used up the mousse or whatever, you throw it away, who cares? Or you can resell the mousse, who cares? Okay, then Costco, the Costco case. Have you seen the Costco case? Okay. Omega watches. Okay, Omega makes watches, and they made them overseas because things are now made overseas a lot more than they used to be, right? So now the watches, what's copyrightable about a watch? I mean, right? I mean, the typeface is not copyrightable because everybody does it, right? You can't get a monopoly on the typeface. So what Costco
you're the Swiss rail system.
Yeah, well, no, they have that was trade dress. And that was a pretty strong case because that's been around for, again, like the Coke bottle. I mean, everybody's like, oh, wow, Swiss. Omega put a little tiny crown. They imprinted a little tiny crown on the back of their watches. That It's a work of art, right? That was the copyrighted righted thing. Well, Costco got a hold of these gray market goods, tried to sell them. Omega sued, saying, hey, you wrongfully imported stuff with our copyright, our amazing little tiny copyright that you have to take off the watch and look very carefully to see. And Costco said, no, wait a minute, we bought these. First sale doctrine. And Omega said, no, I am, but you bought them overseas. That's your mistake. See, in Quality King, the first purchase was made in America, but here the first purchase was made overseas. We made them overseas, you bought them overseas. First sale doctrine doesn't apply until there's been an authorized sale. And it turns out the statute is totally unclear on this. They say the first sale doctrine applies to works lawfully made under this title. Nobody knows what that means. Does that mean, does it have to be made in the United States, or can it be made anywhere? Okay, well, good news. The bad news is, while the case was going up on appeal, Elena Kagan was working for the was the Attorney General. No, she was Solicitor General. She was a Solicitor General, and so she made a recommendation against the Supreme Court taking up the case. And you may have noticed the Obama administration tends to be kind of pro intellectual property rights. It's probably not a coincidence, because while if you look at the two recent presidential candidates, you know how one guy made his money, but Obama made most of his money selling books. So I always wonder, he's a little sympathetic, I think, with rights holders. Well, so unfortunately, by the time it got to the Supreme Court, Elena Kagan was actually on the court. So she had recused herself, and it went 4-4, and the Ninth Circuit opinion stands, and that meant Costco was in good shape. And actually, Omega's now in trouble. They've been found to have misused their copyright. We're watching that one. That's an interesting one. Okay, so Kurt Sang. Kurt Sang was this guy, Thai student, living in America, was tired. Have you guys buy a textbook recently? Right? By the way, it's worse if you're a law student. Everything's more expensive for the lawyers. I guess because we have tons of money. But textbooks are really expensive, right? I mean, they're super expensive. So what he said is, he said, I know, he started buying textbooks from Thailand, same textbook. He'd buy them in Thailand and just bring them and use them. And then he had this great idea that he just got his old relatives to buy up all the textbooks in Bangkok and ship them to America. And he'd resell them to his buddies and then on eBay. And so he got sued for copyright infringement. Now here, at least, they're books and not little tiny indentations in a watch. And now Elena Kagan is no longer recusing herself. So we will get to find out. Now, the problem is the three ways the court could go, none make any sense. One way the court could go is say, all right, they weren't made under this title, therefore, until they're sold in America, the first sale doctrine doesn't apply. Well, now the consequences for that, and Justice Breyer picked up on this right away, he said, that's funny, because if you were to buy a car, guess what's on the car? The car has a computer. What do computers have? They have software. What's software protected by? Copyright. That means we couldn't resell our own cars. That would be crazy. Things are made overseas now. A lot of things have software on them. People don't even know they're copyrighted. But then, the other option is, well, what about books? I mean, these books clearly ought to, we generally don't like gray market goods. And so the court was trying to find some middle ground where they say, oh, okay. Tell you what, the importation is illegal, but once it gets in the United States, you can resell. The problem is the statute's not set up like that. And so, I mean, some of the members of the court were trying to get to there, and that was the position of the United States, the intervening. So there's some middle ground there. I think the court, because of what we're called the parade of horribles, I think they're going to rule in Kurt Sang's favor, and then it's going to be up to the rights holders to go to Congress and get this worked out. Because right now that's my guess. The scary thing is it's 4-4. Last time we did this, it was 4-4, and Kagan, everybody thinks if Kagan was against the Supreme Court taking it, that means she was on the side of the rights holders. After all, she comes from an administration that served on the side of the rights holders. So anyway, did I go on too long? But you have a follow-up, and then you have a follow-up. I didn't answer your question.
My question beyond that is, what actually is, from your perspective, do you think it is Armageddon, like a lot of the parade of horrors?
If they rule in favor of Wiley and they don't come up with some, if they don't come up with some way of limiting the holding, then it seems like we have a lot of really absurd results. And this would apply retrospectively, because, I mean, this is because basically the court is saying, hey, this is copyright law, this is what it's always meant. So I just can't imagine they'll go that way. Guy with the hat. It seems to be where the transaction occurred, because in, oh my God. Yeah, okay, yeah, God. Yeah, cloud stuff. Yeah. The problem with cloud, okay, the thing about cloud stuff, it introduces a whole other raft of problems. But with Mega Upload, the thing there is, if you want to enjoy your digital content, you have to make copies of it. And copies don't fall within the first sale doctrine. First sale allows you to redistribute stuff that you buy, but it does not give you the right to copy it. And that makes digital content surprisingly different. So what's driving people nuts, for example, is you now get a book on Kindle. You get a book on Kindle. It used to be you buy a book with two things, right? Once you buy the book, you can give it away, you can sell it, you can lend it, library can lend it, but it also means you can read it. Well, with digital content, in order to read it, right, it has to go from one storage to another, right? Am I right? Right? It has to go from a flash drive or a hard drive to some kind of RAM, and I understand there's maybe some caching involved, depending on the architecture. You have to make a copy. You have to make a copy just to use your book. If somebody yanks the license, suddenly you can't even read your license. Now, there's been a lot of talk about this poor woman in Norway, right, who had her Kindle account erased. It seems like what happened was she was in Norway and she bought it on Amazon in the United States, and because of very complex contractual relationships, that Amazon took a very conservative view about just the way the book industry works. Sometimes what matters is the way the industry works, and the industry sometimes does not operate in the most efficient way. So Amazon was a little, I mean, they handled it badly, but apparently it had to do with territorial rights amongst the book publishers. But the scary thing is, right, they can do it. I don't know. Yeah, you shouldn't have to. Yeah, you shouldn't have to. The nice thing about Apple, see, Apple has enough bargaining power that they tend to license all of these sort of normal uses you'd make of something you got at Apple are usually set forth in the amazing 50-page license. So, for example, you're allowed to make, to rip copies of songs you buy on iTunes. You're allowed, it seems this way, I got some pushback, unlike Amazon, it seems like you're allowed to, at least Apple does not forbid reselling songs you buy on iTunes, although Amazon does. So, and there's some question, there's a cool site called Redigi that is trying to let people resell digital songs that they bought. And there's a lawsuit going on there. I'm following that. But yeah, I mean, the thing is, what concerns me is that copyright has now entered a realm where it used to make intuitive sense. We all kind of knew what it meant. But with the introduction of digital content, it's no longer making sense to consumers. And I would like, but it will take congressional action to reform it, because otherwise it's going to be case-by-case, fair use type analysis. And if fair use is your defense, you're not in trouble, but you're knee-deep in it. Anyway, you've been waiting very patiently.
No, that's all right, because now I'm going to challenge Larry Lessig here.
Please do.
Okay, So I'm also going to like bastardize Moore's law here that says that technology is advancing at ever increasing rates. So, but yet the laws that govern specifically the terms of intellectual property keep getting longer and longer and longer. So citing the rubber band thing, for example, by the time that under copyright law, by the time that the rubber band issue becomes a public domain, we will have moved to probably digital cyborg technology. I mean,
Yes.
it is no longer important. Yeah, but so
Yeah, the 20-year patent used to be short. That used to be considered a short period of time, but now it's 10 times longer than the technology is going to last.
So Lessig started out thinking, okay, we're going to reform intellectual property terms by going to Congress and going to the courts and saying, let's look at, shortening these things down to something more realistic. Then he discovered that the problem really wasn't, the problem was business influence on the process. That in like in the case you were just discussing earlier, if the publishing house wins or loses in the Supreme Court, which sounds like the more sane option, then their immediate response will be to buy Congress some seats and fund some campaigns and get
They certainly lobby.
laws
They're
changed.
better at lobbying. They have better access.
Right. So I guess the thing is, what sort of action can be taken at a court level? I mean, what sort of action can be taken at a court level to sort of defend the notion of fair use in a more general way?
Well, there's that. And again, if nullification by is when a jury just says, I don't care what the law is, I really feel sorry for this guy, and I'm not going there. By the way, if you're wondering who Lawrence Lessig is, a professor at Stanford. He basically his most radical ways, he really wants to reduce the scope of intellectual property laws. He thinks we'd all be better off with less intellectual property. Since I live in Nashville, and I'm from Silicon Valley, I live in Nashville, so obviously I don't take sides, because all my friends are like art musicians, and they like copyright, but I'm...
All right, in the U.S.
No, the fact that we have, no, that's uncool.
In the U.S., there's the general notion that an industry, a company, is not allowed to artificially manipulate the market. Okay?
There's
the notion that it's not allowed to artificially
I just want to stop you
manipulate
right there, because the problem with copyright, and patent to a lesser extent, but especially copyright, is once you're in a copyright business, you're developing software, you're making music, you're painting pictures, you're writing novels. Once you're in a copyright biz, you are in a regulated field.
Okay.
Because copyright, without the Copyright Act, there would be no protection at all. Congress could tomorrow, they won't, but in theory, right, they could just say, we're getting rid of the Copyright Act. I don't know what would happen, but it could happen. So it's immediately, because the idea of copyright, the idea is sort of supposed to be, we're going to create a kind of approximate market. So, and the tool we're going to give you to create this market is to give you the right to stop other people from doing certain things with your work. But the thing is, as soon as you do that, you're guessing at what a real market would have been.
Well, and that kind of gets to the heart of the issue here, is that I honestly feel like there is, in the days when you actually had to cut down a tree, print paper, put it on a boat, and ship, a book, there was a certain amount of infrastructure and cost that had to go into doing that.
Yep.
And now with digital goods, that is no longer the case.
Yep.
There is still a cost to transport that intellectual property from point A to point B, but it is a hyper fraction of what it was 50 years ago. So what I see now is sort of big media building artificial scarcity into the system, into the economic model, in an attempt to raise prices.
Yeah, well, that's how copyright was designed, right? It's supposed to create because you can stop other people, you can control the supply. But you're right, there was also this sort of natural control, right? Because it was expensive to make these things, and it was expensive to copy them. And of course now it's easy. And I think if you really want to get radical, I mean, I can think of some major changes we could make. But if you really want to get radical, you can rethink the scarcity model. That's what Lessig is, and the folks at the EFF, and and at least Fred
It's
von
okay
Lohman
to be
before
radical.
he went to go work for Google, are suggesting is that perhaps we should rethink the whole scarcity model of copyright. I mean, you have to kind of go back. Get your hand up. I'll just you can go back all the way to copyright started in 1710, and the idea was, you know, if we didn't have copyright, it'd be so easy with the printing press. That was the first radical invention, right? It would be so easy to copy books that nobody would make money off it, and therefore nobody would want to write for a living. And that's still the underpinning, the underlying economic model was this idea that we need to give authors, not the printing presses, but authors rights to stop copying so that they can control scarcity, make enough money during, at the time, it was a 14-year period. 1710, it was a 14-year copyright. But just enough. The idea was, though, if all the writers starved, it was okay so long as they felt just incentivized enough to write. And then in the later that century, in connection with the French Revolution, was this idea that authors are totally awesome people. They are magical, you know, unacknowledged legislators of the world, and they get extra special rights. And we've been living now in this kind of conflict between this idea that authors are special people who get special rights, and perhaps should control whether you can burn a painting.
Last thing, and I'll shut up.
Anyway, that's the conflict.
The Constitution of the United States specifically addresses copyright with a year
It does say for limited times.
for limited time. Okay.
You guys know that, by the way? 188. Yeah, it's what gives Congress the power.
For a limited period of time.
Yeah, it says limited. I know. You're thinking of you're thinking of Mickey Mouse case, basically.
Well, but I'm also thinking of can they radically change the nature of copyright as they have without actually a constitutional amendment?
The answer is I think theoretically no. One thing we learned about Eldred. Okay, Eldred was this case. You know, every time Steamboat Willie comes about to fall into the public domain, copyright gets extended. Okay.
Isn't that in like 2 years or something?
Well, it's no, it was getting close, but no, they tacked on another 25 years. So it'll be a while before this comes up again. And by the way, I have an aside, and again, I don't take sides, but one thing that does annoy me is that I'm a Disney nut, by the way. I love Disney cartoons. I watch them with my kids. But what do you think of, name all the Disney features that are original, based on original stories. So 2 or 3 of them. The rest of them are in the public domain. They have taken things in the public domain, and they don't want to put them back. And then that's kind of supposed to be the deal. You can borrow from the public domain, but then it goes back to the public domain. Yeah, there you go. By the way, good. Pullman wrote just did a great translation of the Grimm fables. If you're into that. But yeah, I mean, but these are fairy tales. They're fairy tales, right? Victor Hugo, right? He was in the public domain. Anyways, I think it's 3. I think it's 3. You know, The Lion King was original.
No.
The really crummy adaptation of The Black Cauldron, that was still under copyright, but God, it's a terrible movie. Great book. God, terrible movie. And what would be the 3rd one?
Fantasia.
Late publication of Alice in Wonderland to get it past the point into public domain. I've always heard that.
Oh, well, they might have. They might have. Gosh, that's maybe. I never heard that, but that's possible. Pinocchio. These are all in the public domain. But anyway, to answer your question, sorry. Eldred also said that the First Amendment, there's no such thing as a First Amendment right, a defense to copyright. And because it's weird, because First Amendment's an amendment in the Constitution, but so is the Copyright Clause. They also said the reason why there's not a First Amendment defense to copyright is that fair use and what is called the idea expression dichotomy were the 2 safety valves that protected our freedom of expression. And if we were to ever monkey with those 2 things, with the scope of fair use and the idea expression dichotomy, then the Constitution would have something to say. Now, as far as the copyright clause, it seems pretty clear that so long as n is less than infinity, I mean, if we read Eldred, if n is less than infinity, Congress can keep extending copyright. And yeah, it's uncool. Anyway, you've been waiting very patiently.
So my daughter has built an arc reactor in the scope of Iron Man,
Okay.
and it's just LEDs and a little processor to make them dance. If she wanted to put this on Kickstarter, at what point does she begin infringing on the trademarks that are involved? Because
boy.
she's not going to say, "Oh, this is Tony Stark's arc reactor,"
Oh boy.
but she's going to convey that idea that it's an arc reactor that you could wear.
Yeah, I don't. Okay, I can't give specific legal advice because I'm not your or your daughter's lawyer, and we haven't developed a attorney-client relationship.
I was going to say I've got a buck.
We can talk about my billing rate afterwards. Oh, sorry, that dollar, it just, yeah, that's over. Okay, it's funny because I just was on the phone on Friday with Marvel characters lawyers who were telling me to go screw myself in a very nice way. They're very nice people, but they obviously think that they're a weak ass case, but they're big enough that it doesn't matter. So right now, number one, I'd say I'd be scared of these people, and I think that they would say they have a trademark in that. Now the question is on trademark. The question is there a likelihood of consumer confusion, or is this a fair use? Is it sort of a fair use? Is it kind of a fair use? And I don't know the answer to that. The question is anybody going to think that your daughter is affiliated with Marvel or with Marvel's owner? Disney, by the way, is a little bit of a lawsuit about whether Disney actually bought all the intellectual property. That's totally screwed up, and I might go talk to those lawyers in connection with what happened on Friday. But you know, there is an issue, and people. Trademarks are funny. Some people have very expansive ideas of what trademarks are. Monster Cables has sued everybody who uses Monster, and they usually lose, but still, because what happens is lawyers will tell you, the thing about trademark is because it exists through use, if you stop using it, it will weak, atrophy, and eventually die, okay? And the mark will go back in the public domain. Lawyers like to tell people that they must keep, if they don't police their trademark will have a heart attack and die. A little different than atrophy and die. And so some companies sue quite a lot. You know, Starbucks, of course, sued Charbucks. Monsters, which I forget even what happened in that case. I know Starbucks lost it first, but it went back, got remanded. So I would be, you know, of course, lawyers we're by nature risk adverse. I'd be nervous.
Okay, I'm not sure whether you're not wanting to go in this particular direction, or I didn't ask it very clearly, but if she just calls it an arc reactor, and she doesn't say it's an Iron Man arc reactor or anything like that, that's what I'm sort of looking at. If she's not branding it with the movie, if she's just saying, I've got an arc reactor.
I don't. Well, help me out. Is arc reactor? The question is going to come down to
it's the shiny thing in his
chest.
chest.
Yeah, but is the word? I guess is the word arc reactor? Was that invented by Jack Kirby?
I think it was.
Okay, so. Yeah.
Does it matter that there's no competing product issue that she's
Unfortunately, not really. It used to matter. It used to be that you needed to have direct competition, and with the Lanham Act, now it's been expanded to affiliation or sponsorship. So even if I'm not competing with you, if it looks like this is something that you know that Marvel might get into, then that's close enough. Then you mentioned dilution, which is where you have a famous mark. And this isn't famous. I feel like I'm pretty confident with that. Famous would be Coke, McDonald's, Nike. Kleenex is, well, Xerox and Kleenex, although those are cellophane, which has now been, it's called genericide, which is where if you use a strong mark to mean the generic thing, the mark dies. That's called genericide. Well, that's just it. I mean, Q-tips, Johnson & Johnson would prefer that you not refer to generic Q-tips as generic cotton tip swabs as Q-tips. But yeah, that's genericide. But so I think the question is affiliation? Is it sponsor? Does it look like affiliation? Does it look like sponsorship? If she does it for fun, that's one thing. Kickstarter is a little more public. There's money maybe involved, and I think that might get some people's attention. And I'm learning to be a little scared of Disney's lawyers. I've gone against them twice. Oh, wait. Sorry. Everybody is sorry. Oh, everybody's pointing at this guy. And I wonder if I'm going to regret this.
Bayer, which is a German
Yep.
company, that the U.S. government actually encouraged that to become a generic term and breaks the trademark.
Yep. Aspirin's another example of genericide, and yes, there was a political edge to that one. Nobody cried at the time. I think Johnson, is it Johnson & Johnson also on that one? I think they would prefer that you refer to it as a adhesive bandage.
This gets back to why fair use is important, because at some point,
Well-
products, services, and ideals become part of our common vernacular and how we
Well,
communicate ideas.
That's what's fair use is important. My problem with fair use, I love fair use. My problem with fair use is that you come to me and you say, well, can I do this? And I say, well, there are 4 factors, and we look at this and we look at that. If everything works according to plan, it might be okay.
Public domain. I meant to say public.
Oh, public domain, yes. Yeah. Things, yeah. Well, it would be nice if things could fall into the public domain. Copyright just doesn't look like it's gonna happen. Trademarks they last forever so long as you keep using them, but obviously there's lots of trademarks that have fallen into the public domain, which you're not really allowed to do with genericide. The reason why genericide there is you're not allowed to take a generic term and make a trademark out of it. You can't sell Apple brand apples. You can sell Apple brand computers, but not Apple brand apples. You see what I mean? Guy way in the back, so you haven't asked anything.
Okay, in my work, I take stuff apart and figure out how it works.
Oh, you the guy back where I parked?
Maybe.
There was a guy who's sort of take it apart. Yeah.
Okay, so let's say I work on vehicles
Oh boy. Okay.
and I want to repair a certain component on the vehicle. And to do that, I need to know how it works.
Yeah.
And this device also has software on it. Now, the software says in the code, it says copyright by Ford Motor Company. Well, I'm not reselling it or anything like that. How has it traditionally been viewed by the courts when a company has reverse engineered something? I'm not copying what they made.
Yep.
I'm simply repairing it or modifying it.
We do have case law on that. Courts have been very sympathetic with reverse engineering and interoperability. The Sega case, where somebody, in order to make a competing product, bought a Sega, it was a Saturn operating system, a console game system, and in order to make a competing product, actually took the code, the firmware, and reverse engineered to see how it worked. And the court said reverse engineering is something we encourage because we like competition, and we're trying to, and so long as the code that comes out at the end is totally different, we will allow some intermediate copying necessary for you to create non-infringing code. Now, there is also in the statute, and I don't have my statute book with me, there is a provision that's meant to help people repair machinery. The statutory exceptions are often very narrow, but the idea is that sometimes you have to make a copy of something so you can fix it. DRM, okay. I'm assuming we don't have any DRM on this thing. DRM falls under the anti-circumvention provisions of the DMCA. DMCA is sort of mixed bag. And the idea is if you get around even lame DRM mechanisms, it's supposed to be illegal. And that's the funny thing is the market has sort of spoken on DRM. DRM used to be a lot more common than it is now. And what's funny is people used to rag on Apple because they had DRM. And it turns out Apple hated having DRM, but they didn't feel like that was something they could win at the time. And remember when the prices went up to $1.29, right? That's when they revised the license and the DRM went away, and so did that provision that said you may not resell. Because Apple, their attitude is happy customers. The rights holders might feel differently, but Apple's. But so I feel like the market's spoken on that, but yeah, anti-circumvention is still a law. I don't see as much. We saw a bunch like in the early 2000s, but we don't see that much anymore. That's also supposed to be illegal to have even a device that. Not any criminal ones, and I can't think of any major civil ones. That's okay. First Amendment helps you out there. So yeah, isn't that funny? You can tell people how to do it, you just can't do it. But the idea though is the First Amendment is supposed to be that by telling people how to do it, you're also making a political statement that this should be legal, right? So that's why the First Amendment, is sticks its nose in there.
If that's the case, then how come Open Start Press had to resend a book on how to access cable modems after needs more information on it? They were basically forced to take that book off the market.
I don't know anything about that. You should be able to tell people how to do things, unless it was another country. Oh, did it have source code in it?
Was that what it was? All I know is that it was just taken up.
Yeah, because source code would be under copyright, and you can of course quote from the source code, and then the fair use fits in there. I don't know why, but yeah, I'd love to hear about it if you could tell me more about it, because that's the sort of thing I try to keep tabs on. It's just hard to keep tabs of everything, even from Nashville, which is the center of everything. Well, it's a nice, it's a nice town. I miss Silicon Valley, but I love living here. Yeah.
There's a situation where a recording artist had a song, they own the copyright to it. Another company used their song in a commercial of theirs, copyrighted the commercial, put it on YouTube.
Yeah.
And then the artist posted their song on YouTube, and then the artist who owned the rights had theirs automatically taken down.
Yeah.
And
Okay.
the person who
Yeah.
did the commercial didn't
Yeah.
even pay them for
Yeah.
the rights to it.
So obviously I don't even have to tell you. Right now, that the person the person who owns the copyright in the song. Songs, by the way, have two copyrights. There's the songwriter copyright and the artist copyright. Right? Copyright in the music and copyright in the sound recording. But the rights holders obviously had superior rights. But we are in an era. I actually am a DMCA agent. It's kind of an interesting job. You get a lot of very angry people calling you. I charge a lot for it because it's psychically difficult. But the problem is DMCA is hard on everybody. The rights holders have to fill out a form and send it on to the right person, and the hosting, right, the internet service provider has to have somebody, and they have to take it down expeditiously, and it's a pain. It's a pain on both sides. So they've developed software. Audio Magic is the most common, but there's other forms that automatically detect. They're supposed to be automatically detecting things that are copyrightable and will automatically take them down. And for the most part, they seem to do a pretty good job, but they're not. They can be pretty dumb when it comes to a situation like that. They can't tell who has the superior right.
That takedown happens outside of the framework of the DMCA.
Yes, and here's the thing, though. Just because it happens outside the framework of the DMCA doesn't mean it's illegal. The DMCA is just a way of, basically what the DMCA says is, you ISP, you hosting company, you would be contributory liable for copyright infringement for hosting this copyrighted material, but we're going to let you off the hook if you do A, B, and C. But they can, if they want, they can take stuff down on their own if they want, if they just want to be careful or whatever, so long as, if they're smart, they'll have a contract with their users saying we can take stuff down whenever we want.
And for what it's worth, you know, as a hacker, I like the notice of takedown system in the DMCA because at least that gives you, because you can file a counter notice and have it
Yeah.
come back up.
A lot of people don't realize that if that happens, the right holder can, or if you think there was a fair use or something, you can put it back. You can send a counter notice to the same guy, same DMCA agent. The downside is you have to give yourself away. You have to give yourself away to say, I live here, basically. I live here. If you want to sue me, here I am. That's the exchange. So, but a lot of people don't even know they have that right. And the problem is the amount of time involved. What if it takes 2 weeks, and what if it's something that's only worthwhile for a couple of days, like, you know, something that was supposed to happen today, you know? Oh, well, actually, what was the Neil Gaiman thing? Right? Who remembers that? Remember Neil Gaiman was giving a presentation. He was given an award, and he had they were going to show the Doctor Who, wasn't it? Where they're going to but they're going to show, because he's written the script for a new Doctor Who episode, and I think they're going to show the trailer, and there was a mix-up on the automatic takedown software, and in the middle of this presentation, and it's also being webcast everywhere, there was a sign saying, "This has been taken down because of a copyright violation," and there was Gaiman kind of going, you know, "I'm not as cool as Neil Gaiman." Yeah. Oh, yeah.
Removed it, you know, that because someone was offended, would that affect their safe harbor provision status?
I mean, that's the way I interpret the Section 512 of the Copyright Act. I think YouTube always has the right to take down anything that they want. The terms of service are pretty clear on that. You know, before you upload anything, you have to accept a contract, and they make it clear they can take stuff down. And and I've heard that rumor that like if they take it down, they'll affect their DMCA status, and I don't get that at all. Now I know some of their copyright lawyers there, and they're smarter than me, but I don't see that at all. I think they have the right to take it down if they want it to. The question is, you know, to me, it's just an internal question. Do they want to, you know, is it fair use? You know, I mean, is it you know, free speech that they want to support, or are they worried about their behinds? But that's their decision. And of course, the problem with Google, what's interesting about Google and Amazon and these companies is what I call the private commons. These are places in on the internet. Lawyers still call it cyberspace, by the way. Yeah, they still call it that, which seem like public commons, but are actually owned by Google or owned by Amazon, and you can be kicked off. And it's sort of surprising because you feel like it's your place, and then it turns out they kick you off. And that's also another, I think, situation where consumers and the law are at a disconnect. Yeah. I think the precedent there, though, is really a consumer precedent, not a legal precedent. I mean, basically, they just don't want people knowing that they'll cave in, and that's, you know, that makes sense. But that's not a legal position. That's just a that's a business decision, really. Yeah. And by the way, are we? I mean, somebody coming here at 5?
No, there's another talk. There's somebody waiting to come in, and we don't want to delay past lunch. So if we could wrap up the questions, maybe one more, and
All right.
talk to them offline.
You had your hand up. Yes. Yeah. That was interesting. So yeah, and I have clients that do this because it's easier. It's just easier. You give the major rights holders, if you trust them, access to the takedown panel, and they don't, you know. And I always advise my clients to say, but we still need a DMCA takedown notice, so we know. So because we want you to. The nice thing about the takedown notice is you have to swear that you have a good faith basis for taking it down, and I try to encourage my clients to insist on that. But still, you know, it's a pain. If you're the host, it's a pain to be the one taking it down. So why not if you trust the rights holder, why not let them do it? What was weird, though, what was Google and what was the situation? Google and a major rights holder got into a public spat over. It was Universal, but what was the Yeah. Yep. Took it down. Took it down, and then Universal said they had a contractual right to do that. Google said no, that's not our contract. And then I think the embarrassing thing is that Google then publicized the contract. Google looked bad. Yeah. Google looked bad. That's right. It was, yeah. And at the time, this is right before they got indicted. Mega Upload actually was suing. Was actually on the offensive. I think my old firm was representing Fenwick and West, was representing Mega Upload at the time. Yeah, cloud computing is right now. All I do is I pray that whenever I deal with a cloud computing case, that all the servers are somewhere in the United States. I mean, that's. And copyright's just one of many issues. Well, yeah, that's. Okay, well, you guys have been a great audience. You had great questions. I hope I answered them. I talked a little fast because you were asking questions that I was really interested in, so I appreciate that. And you know, you can, if you have questions, you can shoot it to me on oh, there's our platypus. You can follow me on Twitter and ask me questions there, or just look up our website, Aaron and Sanders, aaronsanderslaw.com. That's us.